All right, well, welcome everybody. This is the official start of the Expert Evidence Vocational Training Program. Just to orientate everybody, the idea of this program is to offer a very focused but very comprehensive training and ancillary support for expert witnesses and people who work with expert witnesses. This particular video is the first live tutorial, and it will also be disseminated as a recording. So you may be watching this after the event, or if you're present live right now, welcome to everybody. There are quite a number of familiar names, and I know the others that are present. So welcome to everybody for this first session. I'm going to take you through in this session how the vocational training program will work. And we will go through a detailed overview of the paths that are available to you on the vocational training program, and also the idea behind it and how the support aspects of the vocational training will work, as well as the actual content. I think the first thing to say is that the intention of the vocational training program is to provide a very solid platform, both insofar as theory and practice is concerned, for expert witnesses and those dealing with expert witnesses, typically advocates or attorneys, but also mediators would be included within that group. The concept is that there will be a theoretical component which will then, and this is where the important real engine room of the program will then also be translated into practical exercises. So we're going to go through the theory, and then go through the practice, and then bring it all together in a workshop and a mock trial in the advanced section. But I will unpack that in more detail over the course of the next hour or so. What you are currently attending is a live tutorial. Now, these live tutorials will be available if there's sufficient demand and interest. It looks as though we've only just been selling this program on pre-order in the last few days, and we're already over half subscribed. And we're going to really ramp up our marketing and sales efforts during the course of next week. So I'm quite confident we'll fulfill those 25 seats. And provided we've got around about 10 people that will be attending, then to me that's a good cutoff point, and it means that there's sufficient interest for me then to offer a live tutorial. I may offer a live tutorial even with fewer people, because the idea really is to work closely with the participants, work closely with you guys, and try and maximize the benefit that you get from the program. I think I'll just start off by saying that I believe that this is the best expert evidence or expert witness training program in the world. I honestly believe that. And there are other people saying that as well. So it's not just my subjective blowing my own trumpet. I actually don't like to really self-promote very much. But I have to be honest, and I have to tell you that for a particular reason. This is innovative. It's based on my 30 years experience in the high courts in all sorts of cases involving experts. I personally have loved working with experts from when I was very, very newly qualified in my early 20s. All the way through now, and I won't disclose my age, but it's been a while. And I've loved working with experts because of the intellectual challenge and the fact that you never stop learning, and it's the cross-pollination of ideas is phenomenal. But one thing that I've noticed during my years of working with experts, and even amongst attorneys and advocates, there's a common problem, and that is that expert witnesses don't have vocational training. There is no vocational training as such for expert witnesses. There's some very good programs that will give you training on the theoretical aspects of giving expert evidence, and I'm very much in support of those programs and that training, and people do a phenomenal job. I've been involved in quite a lot of that training as well in one capacity or another over the last few years. But there's nothing which equals what, for example, an advocate gets before we go into court. And for those that don't know, before an advocate can appear, they have to undergo pupillage. And as part of their pupillage training, they go through a very rigorous, a year-long program where they are allocated to what we used to call a master. These days it's called a mentor. And they're allocated to a mentor, and they shadow that mentor and members of the mentor's group of advocates to court for the better part of a year. They write very challenging exams, but they also have extensive vocational training. And vocational training covers the theoretical aspects, but there's also a practical component. So as an advocate, for instance, you will be exposed to, let's say, cross-examination in various capacities. You'll be taught in theory, lectures on cross-examination. You'll then go to court, see cross-examination, and then you will also get to do some cross-examination towards the end of your pupillage, where there's actual physical hands-on training. And what that all means is that I was involved extensively in advocacy training for quite a number of years, for I think it was up to 8 years. Eventually, I was training the trainers. So I was exposed to a lot of that training and understand the methodology and how advocates are prepared for their professional careers. And one of the concepts that we had is that that advocates must be trained before they're let loose on the public, is what we said as trainers. And there's a lot in that. In other words, what we try to do as trainers is to, I'm just going to actually stop sharing. I'm talking to you guys directly. Let me just stop that. What we do as trainers is we really work closely with pupil advocates to ensure that the standard of the profession is upheld, that our duty to the courts is maintained, which is paramount as officers of the court, and that advocates know what they are supposed to do, have a solid theoretical foundation, and then have some practical understanding of what they are supposed to do in court from when they first set foot in the courtroom. And I must say, in my life, it's made the world of difference in my professional career, in the sense that it's given me an enormous, from the beginning, even though it's very, very intimidating, and it still at times remains intimidating to appear in the High Court, especially as a junior practitioner, very intimidating, a highly formalistic environment, almost ritualistic environment in court, with a lot at stake, both for your client and for yourself professionally, all of that at stake. And I fell back right from the beginning on the superb training that I received as an advocate, and that prepared me for high court appearances, and then, of course, in the lower courts as well, although that wasn't as intimidating. And I actually feel that in a way, I don't think I really don't wonder how I would have coped if I hadn't had that training. And if I had to just go through and learn in the school of hard knocks and piece together what this high court process is and how you're supposed to navigate it. So I owe an enormous professional debt to the training that I received, and I also thoroughly enjoyed training new advocates and seeing them improve over the time that they were being trained. But what's always struck me is that there is no similar training for expert witnesses. And I find that is an enormous anomaly and is becoming increasingly problematic in our legal system. And I think part of the reason is that when I started, which was now going on 30 years ago, as a candidate attorney, or what we used to call them an article clerk, I've been around long enough I was actually an article clerk, not a candidate attorney. And, those old school values of thorough, disciplined training really applied, but we would encounter expert witnesses back in those days quite rarely. It wasn't a common occurrence that you had to have experts. And I remember when I started as an advocate, if an expert was going to be called in a case, it was quite a noticeable thing, and it attracted a lot of attention, even amongst, and it was challenging, even for senior advocates. And so it was somewhat unusual to have expert evidence in a high court matter. It happened, of course, but it was somewhat unusual. But over the years, and particularly I would say in the last 15 years or so, that has dramatically changed. And expert witnesses now are commonplace. And you may or may not know it, but personal injury cases make up over 90% of the civil roll in South African trial courts. Well over 90%, in fact. So a lot of them are RAF cases, and then, of course, your medical malpractice cases also come into it. And now with personal injury cases, almost inevitably come expert witnesses. And over the last few decades, that expert witness has become really a feature of the courts, and something that the courts have become accustomed to. and it has actually become a more sophisticated type of court appearance, and there's more that's being demanded from expert witnesses as well. So, and the judges are saying this and have been saying that for some time. The law around expert evidence has also developed as experts now make more court appearances. So there are more cases where judges pronounce on what they expect from expert witnesses. And if you go back, as we will do during the course of this program, and have a look at the early days, and I'm talking about sort of more than 30 years ago, you will find that the law actually was quite rudimentary in many respects around expert evidence. And you'll see that some of those judgments and the issues that they dealt with and the way they explained it really seems quite almost simplistic, okay? And as the years have gone by, we've had this increased level that is expected of expert witnesses from a compliance, what I call a compliance perspective. In other words, what it is that the courts and the judges are expecting expert witnesses to do and how they are expecting them to perform. And I believe that expert witnesses are a profession unto themselves. I think it's an emerging profession, a very important profession that play a very important role within the South African legal system. And I actually believe a very unappreciated role in certain respects, and a slightly undervalued role for when one looks, as we will do, when we look at the proper place of the expert witness, a very, very important part of the South African legal system. But all of this is to say that there's no vocational training, which is the equivalent of what an advocate receives, for instance. Attorneys receive similar training. It's not as intense, but they receive similar training. And they also, by the time they get let loose on the public, have a very good idea of what they're doing from a procedural perspective, and insofar as what the courts expect from them. They write exams on it, so they've got a very good idea. Now, when you get to the expert witness, the problem is that experts don't come from a legal background, almost by definition, because they're there to assist the court on an area of expertise which the court can't decide for itself. The judge himself or herself can't understand what the expert is going to say, because if the judge had that knowledge, there would be no need for the expert. In fact, the expert would be irrelevant and wouldn't be allowed to give evidence. So you can't have a legal expert telling the court what to do. So by definition, expert witnesses come from outside the legal domain, and we know that in practice. And the problem with that is that expert witnesses, therefore, don't even have the tertiary level training, the sort of academic training as a cornerstone to their practice, much less the practical training which advocates receive, and to a lesser extent attorneys receive, but let's say advocates and attorneys. So legal representatives, legal practitioners are well versed in the process of the courts, and they learn a tremendous amount, like sponges, as they go through that training process. Experts don't have that. So they have a double deficit and a double hurdle to overcome. What that means is that the sort of foundations for expert evidence is not strong, is not firm, not strong. An expert may be extremely proficient and maybe excellent within their particular field, but they do not, very, very seldom, do they have any sort of proper foundational knowledge as to how they're supposed to appear in court and the court appearances and all the principles that apply to expert evidence. So now you've got a disconnection, disjunct, if you like. You've got the judges increasingly expecting experts to perform at a level which in reality they simply can't reach, because they're not trained, they're not taught, they're not supported, and they're not guided. And it's that gap in knowledge that the vocational training program is designed and aimed at filling. The benefits of the vocational training program are that once that knowledge is filled, and it can be done quite quickly. It obviously takes application, but I talk about a year-long pupillage. You don't have to do a year-long training. You can actually condense that information and set that information out to form a very nice foundation or platform for then the expert to go out into the marketplace and get professional experience, or if they are experienced, very experienced experts, to put this information that they've probably gathered in a bit of a piecemeal fashion together in an intellectually coherent and rigorous framework, and that then shortcuts the learning process and hopefully saves the experts a lot of pain and damage to their reputation, damage to their practice by having to go to the school of hard knocks. Now, there's no substitute for experience. That goes without saying. And I know that, and I know that over the years I've become a much better advocate, even though I had that good training. But I have always drawn on that training, and the idea is to be able to shortcut the sort of level to which you can get as an expert witness through this training. So the training is very much focused on compliance aspect, what the courts expect, and how to live up to what the courts expect. The benefits of that are, firstly, the one obvious benefit is that you are now well versed in what the courts want from you as experts. You have a good idea, and so the chances of you making some major error are dramatically reduced. Doesn't mean you won't make mistakes. Some practitioners are better than others, but at least you know what is expected of you. That's the first thing. But there's a hidden benefit as well, and two hidden benefits. It also means that you're more effective, because you're more effective because you're talking the same language as the person making the decision, i.e. the judge. Or even when matters are settled, you're talking the same language as those who are negotiating and coming to a conclusion, i.e. the advocates and attorneys. So part of the learning process is to learn the language and the thinking of the legal profession, but coming from a particular perspective as experts. So that makes you more effective. It also makes you more efficient, because once you know what you're supposed to do, you know what, Afrikaans called a mikpunt, you know what your mikpunt, your aim, your goal is. It's so much easier to draw a straight line when you know where your goal is. And it's very, very difficult to draw a straight line when you don't know what your goal is on the converse. So those are the essential benefits of understanding what the courts want from you, and how to go about that in broad terms. Just a final point on this introductory section is that it should be becoming apparent from what I've said so far that the methodology which we apply on the vocational training program is a rigorous methodology. We strictly adhere to academic and professional standards of the legal profession. We approach it from a legal profession's perspective. We obviously take into account that we are talking to experts, but those standards are rigorously maintained, particularly in respect of adherence to case law. And it's important that we not teach what I, as Ian Dutton, think would be great for you to do. I try rather what it is, or any of the other people that will participate, any of the other lecturers and trainers that we will get on board. It is not our individual views that matter. We approach it specifically from the perspective that it must have the imprimatur of the courts. Anything we teach, in other words, must be endorsed by the courts, any of the principles. And you'll see in a few minutes how we approach that. But I want to make the point, and it's quite an important one, that the approach which the vocational training program takes is a rigorous approach from an intellectual discipline perspective. We base what we teach you very much on the court cases. We keep an eye on latest developments, and we make it our business to stay on top of latest developments, but at the same time give you like a deep foundational understanding of what you need to do as an expert witness. So those are just the introductory remarks that I want to make. I'm going to now take you to the overview page, and just so that you know where this is. If you go to vocational training, it's the highlighted blue overview. So you can go back to that page if you want to look at it at your leisure, because I'm not going to go through every single thing in detail, because it would simply take too long. But the page is there, but there are a couple of points that I want to make in connection with the page. Let's just start off with the certificate. The certificate will be awarded to you on completion of the 3 modules. The training is divided into 3 modules. There's an essentials, and you'll see this on the expert witness training vocational training tab, there's the essentials, intermediate, and advanced modules. The certificate will be awarded after completion of the advanced module, i.e. after completion of the full training program. Now, you will see from the contents on the overview page that we are very sensitive to people being under time constraints, and we're also sensitive to the fact that it doesn't suit everybody to attend live training. So there are two things that flow from that. We almost invariably will present, when we present any live tutorial or training such as this tutorial, we'll then make it available by recording, and that recording is housed on our YouTube channel, and the recording will also be made available on the training platform itself. And if we just go to the training platform itself, you'll see that that is how it comes up. I'll show you where the training platform is. If you go to the Learning Hub, you will then see, under the Learning Hub, you will see the Vocational Training Program course itself. And here it is, the South African Medico-Legal Reports Expert Evidence Vocational Training Program. So that is where, and you go into that training program, and then you will see the program presented as such. And you'll see that on the training program, we've preloaded already, I think it's 11 topics that we've done. And I will get into those topics with you in a moment. But to get back to the certificate, what will happen is that once you've completed the training program, you will get the certificate. A very, very important feature of this program, as I said in my opening remarks, is we don't want to just teach you the theory and even the practice and leave it at that. We want to take it further. We believe that one of our core values is that for professionals who invest time and energy and money in this training program, they must be able to see that in terms of benefit to their practice. And so we place importance on publicizing the fact that you're doing the training and promoting it to the general medico-legal community, and in particular, in respect of expert witnesses to law firms, to firms of attorneys. And we will also start providing content and really focusing on junior legal representatives as well during the course of the year. That will also be of benefit to them in developing their own practices as they go forward and in developing their professional reputation. So we do a lot of work on publicizing the fact that you're undergoing this training, and that is, in my view, a tremendous benefit of the training. I think it goes hand in hand with the actual technical content. We launched our directory this week, and I think we got 20,000 impressions. I forget the exact technical language for social media, but there was a post on it that did tremendously well, and we intend promoting that directory along those lines, and also publicizing the fact that that you're undergoing this training, which should be good for your practice. And of course, it's up to you to make what you will of it, disseminate it out, and use your own marketing efforts to promote yourselves. But that's an important component. The other aspect of it is that, as I said a few minutes ago, we were actively working with the medico-legal community, particularly engaging on the practical exercises, which will form part of the intermediate when you get the intermediate level. And those practical exercises are going to be done hand in hand with members of the medico-legal community, and that then naturally will bring an interaction between those 25 participants and then leading figures within the medico-legal community. And I can assure you from personal experience that is worth absolute gold, to get those sort of personal contacts and that face time with leading members of the profession, and any member of the profession that is well recognized, is also a very, very valuable part of this training. And we deliberately set out to do that. It's one of the goals of this training. We don't just want to create to provide theoretical training. We want to help you to develop your practice. All right, so that's on the certificate. And then I just want to take you to what Carlos de Silva had to say. Now, this was not specifically on the program, but this was on the intermediate and advanced courses, which we ran late last year and early this year. which really have now been developed into this program. So it's relevant to a lot of the content of this program, but this program has been developed beyond that point. There are quite a number of people who have signed up who did the intermediate and advanced training previously and are now coming on board for the vocational training. But Carlos contributed and has been a stalwart supporter of the project and made a very valuable contribution at various times to sorry, can we just mute ourselves? Somebody's unmuted. And then he says, congratulations on a very well-structured course. A lot of thought has gone into it. I don't think you'll find a course like this anywhere in the world. I'm very proud to be part of it. And, as I said previously, I actually have that view independently. This was something that Carlos mentioned to me without any prompting on my part, but I completely agree with it. I think that this is groundbreaking. I think that there's nothing like this. I'm not aware of anything in the world like this. And I'm very proud to have developed this particular program, and that now we are having the actual launch of this program. I can promise you a lot of hard work and many, many years experience personally, and then from other people as well, that has gone into this program. And we fully intend to make this an exceptional program. Let's just get to the overview of the Expert Evidence Vocational Training Program. It's quite a lengthy overview. I'm just going to scroll through it, so you'll see that there's quite a bit, but I'm going to take you through, I am going to take you through the overview, and then we will finish off by looking at the program itself and how it's structured and how to go about on a daily and weekly basis getting the most out of that program. So if we start off with what the focus of the Expert Evidence Vocational Training Program is, and we have foreshadowed that in my opening remarks, but just to reiterate this, that we focus on the compliance aspects of preparing and presenting expert evidence in the South African High Courts. So I should actually say it's civil work. We don't really focus on criminal work. We do civil work in the High Court. However, the principles that we teach are applicable to any court in South Africa. There are some variations, obviously, between criminal civil work and magistrates court and High Court work. So we do focus on civil High Court work, simply because that's where most of the work is. But the principles, if you understand these principles well, they will serve as a very good foundation for moving into other areas, or if you ever are instructed in any of those other forums, then it's not a difficult thing to then adapt your knowledge. But we focus on civil High Court, and we teach what you need to do and how to do it. And there's a very important practical component there. Or theoretical and practical. So you'll see what you need to do and how to do it. The what you need to do is the theoretical component. And whenever we teach theory, we don't want to go into abstract theory and sort of academic, although academic thinking is very important. We look at it more where the rubber hits the road. What is the practical aspect of this thinking? What do people need to know to practice on a daily basis is really the yardstick that we apply. And then how to do it, and that is really there'll be the exercises and the practical component that I've talked to you about. And to me, that's very, very important. That's to internalize that knowledge. Now, what you need to do, that's a more theoretical component, and that will be dealt with in the first phase, which is module 1, which, if we look over here, is the essentials component. And then we will have the intermediate the component, which will teach you how to do it, and that is more on the practical side, and that is the internalizing that knowledge. We will look at it. There are a lot of exercises to do on how to, for instance, do a joint minute, to understand what pleadings are. We'll show you what pleadings are, how to identify the issues in pleadings. There are many, many inferences, for instance, drawing inferences. We will look at case law. As I said earlier, we will look at a lot of real court cases and how the judges approach, for instance, drawing inferences, dealing with assumptions. We'll look in a few minutes at the extensive scope of this program. And we will teach you, in short, how the judges and how the legal profession looks at all of those principles. And we will then teach you the theory, and then we will take you in keeping with advocacy training and honoring that tradition. We will then give you practical work to internalize that training. Who will benefit from the program? As I said, any expert witnesses, legal representative, or mediator. I'm not going to go too much into that. Just on why there's a need for expert evidence vocational training. As I said to you, I spoke generally about the development in the courts of the concept of expert evidence and how it's becoming more sophisticated and indeed more challenging for everybody, but particularly for experts. And in Twine versus Naidu, which was decided about going on now 10 years ago, Valley AJ had the following to say: most of the challenges faced by the court arise from the fact that the basic principles about the role, relevance, and value of an expert's testimony are often ignored by the alleged experts themselves and by the parties calling them. I'll come back to that word ignored in a moment. This, unfortunately, has resulted in the unnecessary wastage of court time and the unnecessary incurrence of costs by parties. It is for this reason necessary to recall the basic principles involved in the admission of expert evidence. It's comments along those lines that the courts, you can tell from that comment alone, but I can tell you there are many other comments like that where the courts are uneasy about the level of application of the basic principles of expert evidence by expert witnesses. I said I'd go back to the word ignored. I want to double back to that word for a particular reason. I think that's a little unfair, that word. I know, with all respect to the judge, and it's a very good judgment that he wrote. But I feel that that's maybe not quite accurate, because I don't think it's so much that principles are ignored. It's more that the principles are not properly understood by experts in the first place. And that really goes to the point that I've been making for the last half an hour. But my view is I understand the actual cause of the problem a little differently to the way that the court expressed it in this case. He was writing a judgment. I think one has to give him some latitude, but that is my particular understanding of the root of the cause of the problem. Then let's have a look at what is the challenge faced by experts and those dealing with experts, such as legal representatives, mediators. The demands on expert witnesses to comply with their legal duties and responsibilities is rapidly increasing as the prevalence of expert evidence increases. And I've taken you through that, the development over the last few decades. Non-compliance can have a devastating effect on the practice and career of expert witnesses and far-reaching implications for individual cases. However, there's no structured learning which teaches the necessary skills and understanding in order for expert witnesses to comply. You know, when the courts make an adverse remark in a judgment about an expert, and it may not even be on the technical aspect. I'm not even too focused on the technical aspect this evening. I'm more focused on the compliance aspects. In other words, as I said, it's not that I don't think it's that the experts ignore the principles, that they don't understand the principles. But nonetheless, an adverse remark like that can have a devastating effect on an expert's practice. And the reason is that the community gets to know about that. I know that there's senior counsel who keep lists of adverse remarks made against expert witnesses in judgments. And in 10 years' time, you stand up to testify, and the next thing, this judgment, this nasty comment by a judge gets dragged up and get presented to you in cross-examination. And obviously, most desirably is to avoid this in the first place. And that I'm hoping that by undertaking the vocational training program, you at least have a fair chance of avoiding criticism of non-compliance in the first instance. And secondly, if you do have a remark like that, and really, if you are around for some time as an expert, the chances of you having some other adverse remark made about you are very high, to be honest with you. And I know some excellent experts that have had very scathing things said about them. And then the question is, well, what can you do about that? And my suggestion to you is that by experts attending a compliance course of this nature, you can then point to the fact that you've done this training and that you've taken steps now to understand and acknowledge, well, the judge did say that, but you've now taken steps and you've remedied the situation. And let's rather focus on the case in hand, because that now is ancient history, and you have taken steps to address it. So that's another important potential benefit of the advocacy training program. And as I've been through that, there's no structured learning. This course is structured, and I'll take you through the structure now in a few minutes. It's been specifically and very carefully structured to be tailored for experts' evidence. And if we look at the next point, what does the vocational training program teach? Here's where we look at the structure, and this is very important for you to understand going forward in the program. Our structured program is designed to teach you what you need to know about the legal principles governing expert evidence in the South African High Courts. We offer a comprehensive vocational training program which covers 60 key principles of expert evidence. Every expert or other professional work with experts is expected by the courts to know. So it's not something that, it's a good idea for you to know this. No, you are expected to understand these 60 principles. And in addition, if you do understand the principles, it will lend a polish and a sophistication to your work and give you confidence way beyond just the technical understanding. Again, I'm drawing a parallel between what you learn in this program and what an advocate undergoes when they do pupillage. We're going to have a look at those 60 key principles in more detail during the rest of my presentation. How does the program teach the application of the 60 key principles of expert evidence to give experts an advantage in their written and oral work? Just remember, there's written and oral work. The written work is, I would say, the majority of expert work well, certainly is written. The oral work I'm talking about is when you interact, for instance, in meetings with other experts, consultations with advocates and attorneys, consultations and assessments with clients, but most importantly, when you appear in court. That is very, very important part of your oral work. However, your written work dominates as far as volume is concerned, amount of work that you're doing. Most of it is written. But both written and oral work are governed by specific principles. And also the written and the oral work are interlinked. In other words, those principles cover both aspects. And your oral work and written work, one depends on the other. And in one particular respect, I want to make this point at this stage. What you could theoretically do when you stand up in court, even if you may never appear in a trial and give oral evidence, it should inform your work all the way back to when you receive instructions as to what could happen, because that's how the legal system sets it out, and it will give you focus, and it will give you direction, and it will give you an efficient and effective way of presenting your written work if you understand what is theoretically required of you if you were ever to get into the witness box. So those two concepts are interlinked. All right, let's have a look at this then. In addition to the theory, we teach the skills, as I've discussed with you, to confidently use the 60 key principles of expert evidence to your advantage in the preparation and presentation of expert evidence. So we divide it into two distinct sections: your preparation work and then your presentation work. With the presentation work is more what happens when if you go to trial. Sorry, my lights have just gone out, but I'll just carry on. Hopefully they'll come on again, but I do have a backup system, so I'm going to just carry on. In preparation, presentation of expert evidence as a professional expert witness, legal representative, or mediator. Now, what learning outcomes will I achieve through the program? In today's ever more demanding environment, we provide the knowledge and skills to equip you to comply with the duties and requirements of preparing and presenting expert evidence in the High Courts of South Africa. As such, as must-have training. I've dealt with that point. The training is delivered live and on demand. Live training sessions are arranged subject to interest of participants. Typically, live training is held every Thursday evening at 6 o'clock, such as this training. So every Thursday evening, we will have our live training for this course. We will then go through the week's work that has been posted. And if you just want to pass, if you're pressed for time and you feel that the overall program at this stage is too much for you to deal with, but you want to get an overview and you want to get some working knowledge, if you were just to attend the live training, you would then get enough to pass the program and you would get your credits. However, if you want higher honors, then you're going to have to do some legwork on the daily content, and I will show you how that daily content works in a moment. I actually have given you a quick look at the topics and the assessments that come with that daily program. The benefits: avoid a negative judgment. I've discussed that with you, those negative remarks. Inclusion in our directory of experts, and I've discussed that with you. Increased efficiency. I just want to discuss this. Through a proper understanding of exactly what you're supposed to do in dealing with expert evidence, you'll be able to focus on doing what you need to do properly and not waste time on unnecessary effort. I find this is quite an important point with expert witnesses. Because they're not sure what to do, they tend to waffle. There tends to be a lot of information in their reports or in their joint minutes, which is not necessary. And you can actually see they don't know exactly what they're supposed to do. So they're not really goal directed. And that takes away from the effectiveness of your report and the efficiency. So you're more efficient because you don't have to waste time and effort going into things that aren't actually relevant. You can get through your reports quicker and you're more focused. That also increases your effectiveness. This clear understanding leads to increased confidence in your work. This helps achieving the ultimate goal of expert evidence, written and oral expert evidence, which through a process of logical reasoning persuades others to the opinion expressed. Okay, I just want to unpack that. So because you know what you're supposed to do, it makes you more effective. You're more confident. You know how to present things. You know how to cope with situations. You know how to deal with unusual problems that might come up better than your counterpart. And that's another point. By doing this program, you are now in a position of advantage over your competitors and against people who may be opposed to your views. You'll get a tremendous advantage in your practice. And then I just want to take you, just hidden in there is a very important concept. And I say through a process of logical reasoning to achieve the ultimate goal of expert evidence. And, let's just sort of sit back, and we will deal with this in the program, but what is the ultimate goal of expert evidence? It's to persuade others to your opinion. If you think about it, you're making an argument. And if you're going to make that argument effectively and convincingly, it really helps if you understand the general norms and values and way of presenting evidence and information in court. It makes you more polished. It gives you direction. It gives you confidence. And again, it raises you above your peers. So it gives you all sorts of tremendous advantages. Let's just have a look at the assessment quickly. How's the work assessed? Each module contains a written and video content with a self-assessment questionnaire. A final assessment will be done at the completion of the program. The pass a class salutatorian and valedictorian will also be awarded. Just to unpack that. So each module contains a written and video content. And I will show you that each of those 60 key principles will have a written and video content. That will then relate to each particular topic. We've got the pass marks, and I just want to quickly, the class and valedictorian, basically that's second and first place in the class. And I just want to then take you to the other tab, which will show you how the information is presented. So you've got each topic relates to each key principle, and we'll look at that in a moment in detail. But take, for instance, the expert's duty to the courts. You'll see that there's the topic and there's the assessment. We're on the topic. The topic will have written content, and if you go to materials, there's a video which will then explain the written content. It's not just the regurgitating, it's to contextualize the written content. And there will also be a reference to the expert witness guide, which is the textbook that accompanies the course. Please make sure that you've got the textbook. If you haven't got it, please contact me. We will make sure we get the textbook to you. It will really enhance your learning. So you'll see that each of these topics, topic 1.2, topic and assessment, and we follow the same format for each topic. The assessment, I must tell you, it's a self-assessment. If you want to, you can go to the end of the assessment. It'll give you the correct answers in many of them, not all of them, but in many of them. But here's the assessment. But I would encourage you, don't do that, because it's really there to teach you. So rather do the independent work. We may actually remove that ability to look at the questions. We'll consider how that goes. But it's not there to trick you or anything to catch you out. It's there for you to reflect on the topic content and then to assess yourself and see whether you, in fact, have a proper understanding of the subject. We make sure the questions relate to the most important principles in the topic. If you get those questions correct, you can see that I've got 0 out of 3 there. But if you get the questions correct, then you can be assured that you are understanding the topic. And also, at the end, at the assessment, at the end, the final assessment will be based on the questions which come from these self-assessments. So I would very much encourage you to do the self-assessments, and please take them seriously, especially if you're going for higher marks. And then just insofar as time commitment is concerned, we're all professionals. We understand that this is a significant investment, more of time. The money, I think it's very, very good value for money, but yes, it does cost. But really, it's the time taken that is the most important investment. And there we would like to give you the opportunity to tailor how you want to approach this course. And that's why we say that depends on what mark you want to achieve. For a 50% pass mark, a commitment of 2 hours per week to watch or attend the live tutorials is required. For higher grades, a daily commitment of 1 to 2 hours will be needed to go through that content. Or if you want to do it on your weekends, you can then spend a morning going through that work on the weekend, and then you will be in line for one of the higher honors, which is a distinction or the cum laude or the summa cum laude. Then just insofar as payment is concerned, again, there are 2 options. You can either get a 25% discount if you pay once off. That seems to be a very popular option. But there are certain people who are paying it off over 4 months, and that's 2,749 to 2,750 basically rand. That 25% discount is a significant amount, the 2,750 rand that you would save there. Your payment options, you can buy it online, but I would encourage you, get hold of me, let me invoice you, so that I know that you're on board. I can make sure that your registration is smooth and that you're in the fold. I can welcome you nice. If you want to do it online, you can do that. But I actually like to personally do the invoices. I'm keeping the numbers down to 25. I'm sure I could sell a lot more than 25 seats, but I want to keep this down so that I can work very closely with you. There's a compliment there from Lorna just talking about against the advanced training, which will come up later in the course. But really, there are videos on this. You can go and look for yourself. Really, that class was phenomenal, and it was much enjoyed by the participants. Now, if you just look at the curriculum, so the program provides a step-by-step guide to expert witnesses and those dealing with expert witnesses, from receiving instructions to testifying at trial and everything in between. So we go from A to Z, and we've been through what you're required to know, what to say, what to do, and how to do it in respect of each of the 60 principles. And I just want to quickly have a look at, I'm not going to go through all the principles now, but I just want to give you a flavor of what those principles are. Part 1 is your preparation for trial, as I said earlier, and part 2 will be the presentation for trial. Now, this is important for you to understand the overall structure of the program, and don't get confused. Part 1 will cover 30 key concepts and principles governing preparation for trial, and will deal with the following specific topics. So principle 1 is the expert witnesses' duties to the courts and to the public are similar to the duties owed to the courts by attorneys and advocates. So attorneys and advocates are regarded as officers. Well, they are officers of the court. They owe duties to the courts, and you will see through the program that there are judgments saying exactly that in respect of expert witnesses, that they owe duties to the courts similar to the duties owed by attorneys and advocates. And that is why I say that one of the reasons I say that expert witnesses are a profession unto themselves. In fact, it's a profession on equal standing insofar as their duties are concerned to the courts as advocates and attorneys. And one of the aspects of that is from time to time we have judges dealing with experts in a dismissive or disrespectful way. That is frowned upon by the senior courts in the country. And we did a tutorial on this a few weeks ago, where the Supreme Court of Appeal admonished a judge for not dealing with expert witnesses with the respect which they deserve. And I think that's one of the results of the expert witness profession not being clearly recognized. But legally, expert witnesses owe the same duties as advocates and attorneys. Now, I just want to take you to how we teach that. So that is the principle. Then we'll teach the theory, which is in the Essentials module, topic 1.1. So we will teach the principles themselves. Now, the idea is that module 1, which is this module here, the Essentials module, is designed to give a quick overview of the whole landscape, get you to understand the overall lie of the land as far as all the principles are concerned. So it'll take you relatively quickly through that. It'll take 2 to 3 weeks to get you through all 60 principles with the topics and the assessment. And then once we've done that lie of the land, then we turn to the intermediate level, which you'll see there, intermediate level. And on the intermediate level, that is the practical level. We then take those concepts and we then apply them in practice. There will be exercises There will be specific practical training. We will give you examples of pleadings. We will give you examples of joint minutes, and we will work very closely with the medico-legal community, and already are, to set up those exercises so that you get the most out of those exercises and you can see exactly how that theory works in practice. And I believe that is really where the engine room of this program lies, was in that intermediate module. So we will, on each specific principle, we will take you through the theoretical component to give you an overview so that you understand the landscape, and then we will dive into each individual topic and go and drill down into that topic and get you to internalize it from a practical perspective. Why do we do that? Because if you try and teach something in too much detail without understanding the overview, it can be terribly confusing. My view is that the best way to understand the topic is to first get the overall lie of the land, like the map set out, and then you go to all the individual points in the map. And once you understand the context, you as a human being can now start understanding individual concepts more easily. So there's a specific methodology to that. And in fact, that methodology applies. If you read the textbook, like the Expert Witness Guide, go to the content section, have a look at the table of contents, read through the entire table of contents before you go into any section. Take you a few minutes, get an overview of what the whole subject matter is, and then you can go and dive deeper into any individual points. And so we have, I'm going to just take you through a few of these examples. I really wanted to show you how the theory and the practice works. The theoretical, the module, this is how module 1 is presented, as I showed you, with the topics, with the video, and then the assessment. It'll be a similar methodology for the intermediary course, but this is very much how we do module 1. Principle 2, for instance, is importance of helping the court, the concept of appreciable assistance, and why it is important for experts to view themselves as assessors of fact to assist the judge in coming to the right conclusion. Now, those of you who've already done the intermediate and advanced training will recognize this principle, and there are a number of other principles where you will recognize the principle. However, we are going to develop that learning that you went through in the intermediate and advanced training, and we're going to develop it particularly with regard to the practical aspect, which will come up in the intermediate module. Principle 3, techniques in getting and keeping the ear of the court. So we'll go through the theory of each one of those principles. And so we can scroll down and you can go and have a look at this in your own time. It's on the website. I would encourage you to do exactly that. Spend a few minutes familiarizing yourself with all the topics. And then you'll see part 2, presenting evidence at the trial. And that is where we then deal with, so there's 30 on your preparation principles and 30 principles dealing with the presenting evidence at trial. I made the point earlier that there's an interrelationship between the two parts. Don't think that the presenting evidence at trial is in some way divorced from your written and preparation work. It very much influences the correct way to do your preparation work, and you'll see that in detail through the program. And I'm just going to just at random pick a couple of topics to give you a flavor of part 2. What to wear to court, the layout of the courtroom, the main role players in court, what the difference is between an advocate and an attorney. So you see these are very practical court-based principles that you should know, you should be comfortable with and familiar with, even if you've never appeared in court. If you have appeared in court, it will help you to understand this. But at least when you get to court, you'll have a good idea of what you should expect and how to handle that particular situation. And then just to finish here on the advanced module, the advanced module will then demonstrate the application of the 60 concepts and principles in a workshop and mock trial. So we will then bring all of that learning together. We will focus on a number of principles and then have a look at that through the mock trial. We'll expand on the mock trial from what we did last time in the advanced course in a number of ways that we will let you know about. But we will then workshop it, and then we will take it to the mock trial concept to demonstrate. So that is an overview of the training, and that is how the program will work. Just insofar as sort of commitment, and I said daily and weekly and what have you commitments, for those that are intent on, and also I should just make this point before I move off it. that this information will obviously sit and be available for, you'll have access to information indefinitely. So at any stage, if you've got a particular issue that comes up, you can dip back into this information and go and brush up on your learning, and there'll be an accompanying video, etc. And you will have the textbook. So it should bring that textbook to life and really start bringing this information and content as being very usable and practically applicable for expert witnesses or for anybody dealing with experts. And then just insofar as the other point, which is that if you don't want to go through the daily, then we will have the weekly content. Next week we will start going into content. That video will then be made available. It'll be available for you to refresh your memory or to brush up for your final assessment. And if you just watch the content videos, you will then be fine to get your 50% at the end of the day. All right, thank you very much for your time. I tried to finish this in an hour. We're 3 minutes short of an hour. Thank you for your time, and we will please go and have a look at the content that's been preloaded on the site, and we're already moving. We will place everything as it's released. It will go onto the WhatsApp group, and we will then work from there. Thank you very much, everybody, and we will be in contact with each other and work closely through this program, and we'll start with our actual tutorials themselves from next week. Cheers then. Bye-bye.